that dress is blue. No, it's gold. No, it's blue. No, are you blind? It's definitely blue.
If that dress was a provision of the Constitution, it would definitely be Section 92. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about one of the most litigated sections of the Australian Constitution, Section 92, the absolute freedom of trade, commerce and intercourse among states. For almost 90 years, Section 92 has given rise to more than 140 cases. It is the most litigated provision of the Australian Constitution. Sir Robert Guerin, one of the main commentators of the Australian Constitution, has even joked that when students are reading Section 92, they may just drop the books, sell them and go study something easier, something like higher mathematics or nuclear physics. Don't do that though, because in this video I'm gonna tell you what you need to know about Section 92. So don't give up on law, just hold tight and let's go through this video. But since I'm helping you here, why don't you help me as well by clicking the like button and subscribing to our channel? Do you remember that one of the main reasons for Australia to become a federation was to allow for a certain degree of freedom of trade and commerce among the colonies? We have talked about this before, and you can check some of our videos by clicking on the top right corner and watching the videos about Australian federalism, Sir Henry Parkes and Sir Edmund Barton. Pre-federation, some people in colonies were quite protectionist, not only in relation to the goods imported from outside of Australia, but also from the trades within Australia between the colonies. There were some barriers between the Australian colonies themselves. So the framers of the Australian Constitution decided to eliminate these many barriers to free trade and commerce among the states by putting some provisions in the Constitution. Section 51(1), for example, grants the Commonwealth Parliament the power to make laws with respect to trade and commerce among states. Section 90 creates the uniform customs and excise duties to replace the many states' duties. Section 99 prohibits the Commonwealth from giving preference to one state over the other by regulating trade, commerce or revenue. And there are some other sections in the Constitution as well about that, like Section 98 or 102. So Section 92 then is part of this package of measures to prevent barriers on trade and commerce among states. Section 92 tries to ensure that Australia will become this free trade area, where discrimination against interstate trade and commerce is prohibited. Do you remember that this was one of Sir Henry Parkes' resolutions for the new federation? Trade, commerce and intercourse among the states after the federation should be absolutely free. This is the reasoning behind the constitutional provision. So let's take a look at it in more detail now. Section 92 then says that on the imposition of uniform duties and customs, trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Let's divide these into smaller chunks. But let's start by addressing the elephant in the room, the terms absolutely free. People like George Reid, who was Premier in New South Wales, said that this was a bit of a layman's language, but that it conveyed exactly what it should. The idea behind the provision was to show that trade, commerce and intercourse among the states should be as free as it could. As Quick and Guerin said, this section is intended to provide for the perfect freedom of trade and commerce among states, from the moment of the imposition of uniform duties. In order to secure that object, the strongest possible words have been used. Nothing has been left to implication. Now, the term itself has some obvious limitations. For example, absolutely free does not mean that you can have trade and commerce of slaves, or drugs, or explosives. Only lawful trade and commerce is absolutely free. When reading this provision, we have to remember that in law generally, even human rights, there's no absolutes. But what does Section 92 then says that will be absolutely free? It mentions trade, commerce and intercourse. What are these things? What is involved here? Historically, this provision has been divided into two limbs: the freedom of trade and commerce limb and the freedom of intercourse limb. we will analyze the recent case of Palma and Western Australia from 2021 to assess whether this division still exists today. Make sure you subscribe to our channel and that you hit the bell icon so that you won't miss this upcoming video. We can guarantee that Section 92 involves the right to introduce goods, wares and merchandise from one state into another, the right to sell the same, and the right to travel unburdened by state restrictions, regulations or obstructions. The judicial definition of trade and commerce was established in a case called W&A MacArthur and Queensland from 1920. In this case, the High Court accepted that the ordinary meaning of the words trade and commerce should be used. So they said that the mutual communings, the negotiations, verbal and by correspondence, the bargain, the transport and the delivery are all but not exclusively parts of that class of relations between mankind which the world calls trade and commerce. So not only the trade of goods, but also intangible things and the art of trading as a handicraft can all be considered within the scope of this concept. And all of this, according to the text of Section 92, is to be absolutely free. Okay, Section 92 seems to indicate that at least this time we're actually talking about rights.
Finally, Renato, you've now made a video about an express right in the Australian Constitution.
Well, hold your horses. The High Court of Australia has indeed adopted the view that you're pointing out for a long time. Since the early cases related to Section 92, the High Court defended what has now been called the individual rights theory. This individual rights theory dominated the jurisprudence of the High Court until 1988. This theory basically asserted that there were only minor limitations on the content of trade, commerce and intercourse. Just as the examples I was giving you before, trade, commerce and intercourse would be absolutely free insofar as it was lawful. So when reading Section 92, the High Court of Australia was actually acknowledging this individual right, and so parliamentary interferences had to be justified to be considered constitutional. To support that approach was also the view that Section 92 only applied to the states and didn't quite apply to the Commonwealth. This was a way of conciliating the limitations of Section 92 and the power given to the Commonwealth under Section 51(1) of the Australian Constitution. So, under this individual rights theory, it does seem like we are talking here about an express right in the Australian Constitution. But all of that changed, however, in a case in 1988 decided by the High Court called Coe and Whitfield. There, the High Court adopted a new approach to interpreting Section 92 called the free trade theory. The thing was that the context of Section 92 and its creation didn't seem to provide support that it was an individual right, but rather a limitation on parliamentary power. So since the case of Coe, we can say that this is a negative right or freedom, a limitation on parliamentary action. Or as I've been calling them, express rights, with quotation marks. If you want to understand what was the new approach adopted by the High Court to interpreting Section 92 of the Australian Constitution, the free trade theory, make sure you subscribe to our channel and wait for my next video, because there we will analyze the case of Coe and Whitfield from 1988. I hope you liked this introduction to Section 92 of the Australian Constitution, and I'll see you again soon. Until then, ciao.